Well, hello, and welcome to another edition of Thursdays Live with Nevada Legal Services. Today, we're going to be talking about appealing PUA and UI decisions through the judicial review process, and also giving an update on writs of mandamus. I did just want to make sure everybody is aware we're going to be talking about our website. We do have a new web address. It's nevadalegalservices.org, and all of the the petitions for judicial review forms that we're going to talk about are up on our website. We are going to be talking about a modification of our writ petitions, which I will post after this live stream. But again, my name is Ray Gertkin, and I am joined by David Olshan. Hello, David.
Hello. I don't need my bright light, do I?
Once David gets back, we'll go ahead and get started. But please remember to post any questions you guys might have in the chat for the live stream, and we will try to answer that as we go.
Who has to get back? Jojo.
And then just a reminder that this is general information, not specific legal advice to you. We are not your attorneys. We are just providing an educational service. If you do ask a question, please make sure that you do not include any confidential or personal information, as this is a public forum. This is also our view, and other reasonable people can disagree. So please keep that in mind. And then please also understand that we are a nonprofit. We try to help as many people as we can, but we cannot help everyone. So just some disclaimers to get through before we get started.
Your mileage may vary.
All right, David, do you want to get started with the continued issues with Dieter?
All right. So we have for a while now been seeing these notices that contain the words invalid appeal. And we haven't really figured out what the legal basis for this is. There doesn't seem to be any legal basis, because under PUA and regular unemployment, you have the right to appeal and you have the right to be heard. So an invalid appeal seems to be against most sort of common pedestrian, non-lawyer notions of fairness and due process. But usually we see that when somebody has filed a late appeal, and there are reasons for filing a late appeal, and those people who have filed late are entitled to a hearing. So we've begun to file writs on their behalf because they have no adequate remedy at law. And there's this other making a statement. Apparently making a statement is cause for an invalid appeal. Everything you do, pretty much every time you interact with the Employment Security Division, you make a statement. So it's kind of you kind of wonder who came up with that language, but making a statement or filing a late appeal could subject you to an invalid appeal. Please contact us, or we're going to be talking about writs of mandamus. You can file a writ of mandamus if you get an invalid appeal. It's illegal, and it is mind-boggling, and I think that's probably why they're catching up with so many of their cases, because they're just giving these invalid appeal notices. Also, with regard to self-certification, the division, Employment Security Division, will give you 48 hours. That's not correct. Under federal law, you have 21 days. Sometimes you have longer than 21 days, but the shortest period of time you can get is 21 days. So if they ask for documentation of your self-employment income or any type of documentation, they have to give you 21 days before they deny your benefits or accuse you of fraud or something else. They're not doing that. They're giving you 48 hours. So that violates federal law. There's three reasons to waive an overpayment, and it's the Employment Security Division thinks it's just like regular unemployment. So it's whether you have the ability to repay. That's not it. If you change your position, it's called estoppel. If you change your position relying on these benefits and then they're later taken away from you, that's estoppel, and that might be a reason to waive the overpayment, or just collection of the overpayment would be unconscionable. There's three different reasons against equity and good conscience, estoppel and unconscionable. It's in the federal law promulgated by the Department of Labor, But again, when you go to an overpayment hearing, you might just be subject to, can you afford to pay it back? And if so, you will have to pay it back. That's not the law. That's not the law they have to follow for PUA overpayments. And I'm just talking about PUA overpayments here because there are 3 different reasons to waive the overpayment, and the Employment Security Division is only using one. And then, of course, we know delays in deciding whether you're eligible for PUA, in scheduling a hearing, in having a hearing, and getting a decision from the appeals tribunal or the referee, appealing to the Board of Review, getting a decision from the Board of Review. There's just unreasonable delays on all sort of different junctures in the PUA application process. And so those are also violations of the law, and it happens all the time. Wow, okay.
So I guess, there are still problems, but as we're getting through some more hearings, obviously we have hearings scheduled through probably the spring at this point, 2022. As they get through the hearings, though, there could be a delay in issuing the decision. Once you get that decision, it could be unfavorable. And we're going to talk about, well, if you get an unfavorable decision, what happens next? And this is the same process for both unemployment and PUA. Before we move on to the judicial review process, David, is there anything else that you want to say regarding the continued issues?
No, but I would encourage people who are watching to be advised that a writ of mandamus is not appropriate if you've gone through the administrative process. If you've gone to the hearing, gone to the Board of Review, you're going to do a petition for judicial review, not a writ of mandamus.
All right, so we're going to, part of this educational presentation is to give you guys the information, knowledge, and forms that will help you file on your own. As David said, when you're looking at the self-help writ petitions, you're looking at whether there, if there's no hearing, no decision, or your benefits stopped. If you've gone through the process, if you've had a hearing, if you've gotten the decision, you do need to file an appeal. And we're talking about you have your hearing. If you lost at that hearing, you can appeal to the Board of Review. If the Board of Review again decides that you're not entitled to benefits or doesn't issue a decision, just say, there might be a decision saying we just accept the decision of the referee or we're not going to review it. Then you have 22 days from the Board of Review decision to file a petition for judicial review. That is a court appeal of an administrative hearing process. So there are 2 different court processes that you'd have to go through depending on what issue it is you're having with your benefits. And then again, as I said, NevadaLegalServices.org is our website, and you can go to our forms page. It is /forms, or you can get to the forms page from the Know Your Rights menu.
And I just want to add or point out, Ray, you know what you're talking about, but you did say 22 days. That, in effect, is what you get. But the statute and the rules say 11 days. So, if somebody's going to quibble like, oh, it's really 11 days, they in effect give you 22 days, but the statute only requires them to give 11 days.
Right. And that's because the Board of Review decision becomes final 11 days after it's issued, and then you have 11 days to appeal. So that's why I said 22.
No, I know. If you can see somebody saying, oh, you're wrong, Ray, it's really 11 days. Man.
Right. But the Board of Review, and this is, as David said, it is in the statute, it is in NRS 612, but it does take 11 days for the Board of Review decision to become final, and then you do only have 11 days to appeal. The 11 days is obviously the time frame you have to appeal your hearing decision to the Board of Review, so it is 11 days all the way through. You just get the Board of Review decision allows for the 11 days to review it and decide what to do before. All right, so in order to file a petition for judicial review, you really want to make sure that you actually do qualify. I mean, we have a central question that everybody has to determine before you're going to move forward. Are you eligible for PUA? So just remember, to qualify for PUA, you have to have a COVID-related reason for being out of work. You have to not be eligible for unemployment benefits, and you cannot work from home or telework, and you didn't receive, vacation or severance or some other benefit, sick leave or something like that. Obviously, we're probably well beyond that at this point, but If you received any sick leave, you were not eligible for benefit. So again, we've said this before, you file the writ when there's no adequate remedy at law. So that's when they don't give you a right to an appeal, they don't give you a hearing, or the delay is too long. So when we're talking about a petition for writ of mandamus, we're talking about the long delays. If you haven't received a decision within 7 weeks of your initial claim, or if you've been denied a fundamental right, which is that they've determined that your appeal is invalid without giving you a hearing, they've stopped your benefits without giving you a hearing or any notice. Those are the issues that we're looking for with the writ petition. For the petition for judicial review, that is the appeal essentially of the decision if you went to your hearing and appealed to the Board of Review. So we're really talking, in the normal scheme of things, you have to what we call exhaust your administrative remedies, which is why you're filing the writ petition, essentially is to get that appeal hearing. Once you've had that appeal hearing, you do have to file an appeal to the Board of Review within 11 days. Once you get the Board of Review decision, you then have to file the petition for judicial review in district court in order to appeal. All right. So petitions for judicial review. We're going to talk about filling out the petition for judicial review itself, and then the summons and civil cover sheet. We are going to talk about service of the petition for judicial review because that is the, one of the major issues that we're dealing with in terms of ESD.
And Ray, can I interrupt for 1 second?
Yes, please.
First of all, this petition for judicial review, the federal law is pretty clear that a PUA denial is subject to the same appeal rights as regular unemployment. So if you go to our website and you see the regular unemployment petition for judicial review, it should be very similar to this video. It's pretty much the same thing. And the other thing I need to mention is, yes, you get 22 days or 11 days, however you slice it. But the point is these petitions, the petition itself should be simple and easy, and getting this started and filing within 11 days should be pretty easy for most people.
It is it's a 2-page form because of spacing, but essentially your grounds for appeal are just what I've listed. This is administrative, court review of an administrative decision. So you do need to argue that the decision was not supported by substantial evidence, it was arbitrary and capricious, it was marked by an abuse of discretion, or is improper as a matter of law. So those are the 4 grounds. And then this is basically what we've been talking about in terms of the form. It is a very simple form. It is a petition, for review of the decision of the Employment Security Division. And it does lay out those 4 grounds. So that's basically it. That's what you need to get filed in the district court in the county where you work.
And look, a lot of people are going to say, I want to put everything into this petition. They need to know how I was screwed over. Don't worry about it. You'll get an opening brief, and opening brief is tough enough. So don't worry about the actual petition for judicial review because it's simply a formality to get your ticket into district court.
Exactly. That's just opening the door to the court to get your argument all in front of a judge. You just need to get this filed on time. So you do need to, as I said, you need to file in the court where the employment occurred. If you're working out of your home, the employment occurred in the county where you live. Otherwise, if you went to a work site, again, the employment, it has to be filed in the county where the employment occurred. Now, that county might require you to e-file it, or it might just be a paper file. That's something that you need to determine from the court, whether or not you need to sign up for an e-filing account, or, just if you can file by printing out the paper and filing it in the court. Again, you just get that petition form, you sign it. There are 2 other documents that you need. That's the civil cover sheet for the court in which you're filing. Most district courts do still require a civil cover sheet. You just go to the district court's website and you can print out a civil cover sheet. The other thing you want to print out is the summons. You will need 4 summonses because you are technically suing 4 people or appealing against 4 parties, essentially, in the petition for judicial review.
Yikes, Ray, I'm sorry, I forgot, but there's no employer with a PUA petition. I think you included it.
Oh, I did. Okay,
Yeah.
I will modify that and take it
Yeah,
out.
sorry.
Yeah, no, that's all right.
The legal
Because you
process.
are, well, no, there's an employer, but they don't participate. So yeah, I see that.
Well, it might be you, so you'll be on top of the
Oh yeah, if you're self-employed, yep.
petitioner.
All right,
that
well, I will
is-
fix that and post it on our website, repost it on our website after this presentation. So so you just, you need your civil cover sheet, your summons, and your petition for judicial review, and we're going to talk about the summons in more detail. When you go to file it, you need to file your petition. You need to submit your cover sheet. One thing you do not need is a filing fee. This does kind of impact people because if you're filing, if you don't have the money to pay, say, a filing fee in court, or you don't think you do, most people want to file a request to waive the filing fee. You technically do not need that for unemployment appeals, petitions for judicial review. So, when you go to file, you might have a clerk that's going to ask you for a filing fee, but under NRS 612, you are technically not required to pay. So just, be aware. I think most courts probably know this by now, but there are probably some that still do not. So just keep in mind that, there might be a clerk that asks you for a filing fee, or you might feel like you need to fill out a fee waiver form. You do not. You are not required to pay a fee to file. So you have your petition, you file it, you have your civil cover sheet, you file it, you have your summonses. Now the summonses technically don't get filed at that point in time, but you still have to have them issued by the clerk. Now this is going to be confusing for people who are e-filing because you do have to, there's usually a summons issued code. But again, depending on the jurisdiction you're in, your e-filing system could be different. Because they do use different systems in Washoe County and Clark County. But please just be aware that your summons needs to get issued by the clerk. And this might be something where you want to call the court clerk and see if you can have the summons issued in person. So you can file the petition online. You might want to have your summons issued in person because the clerk will actually emboss your summons and hand it back to you. You have to hold on to the original summons until you actually serve the petition. So I know that's a lot. Summonses can be confusing. We have instructions that go along with this on our website as well.
Right. And when you say issue, basically the clerk or the deputy clerk just signs it. So if you have a summons that isn't signed by the clerk or anyone associated with the court, you need to go back and get that.
And then you don't serve the original. They actually give that back to you. You have to hold on to that original copy, and then you make 4 copies of that to serve with your petition. All right, so you've got your summonses. One of the things we talk about in the instructions, and one of the things we've talked about before, is service of the petition for judicial review. Can you serve it by mailing? Technically, yes. You should be able to serve the petition for judicial review by mail. The Supreme Court issued a decision. Unfortunately, it was pursuant to the Administrative Procedure Act, which doesn't, unfortunately, the unemployment statutes under 612 are the same or similar. But this was a decision that wasn't under Chapter 612, which is the unemployment decision. But it was a decision that administrative appeals can be served by mail. Unfortunately, the Employment Security Division disagrees. So what we've been seeing is that the Employment Security Division is challenging service by mail and attempting to dismiss petitions that weren't personally served on. We believe that service by mail is completely appropriate, and the Supreme Court has basically said that. But we understand that people might not want to risk that service issue. That's why we're talking about serving a summons. But if you want to serve by mail, we believe you're certainly able to do so. You would just need to mail a copy of the petition to the administrator for ESD. That's explained in the instructions as well. And then file a certificate of mailing to verify that you did that. So if you do decide to serve by mail, you can ignore everything I've said about a summons because you do not need to get a summons issued. You just need to mail the petition to ESD and then file a certificate of mailing once you've done that. There is a risk to that you are likely going to face a motion to dismiss. If you do, please feel free to call us at that point in time and see if we can help you with that further. But again, like I said, I understand people might not want to take that risk. That's why we're talking about getting the summons issued and then serving the petition personally.
And the old adage, actions speak louder than words, it really shows the unfairness of the Employment Security Division wanting to exclude you from getting benefits by objecting to service by mail. Service by mail is a pretty straightforward, logical, simple argument, but the Employment Security Division is going to want a court to tell them, not logic and clear reasoning. So the fact that they make this harder for everyone means that they don't really want to disperse those benefits. They don't really want to help you. And that's the whole reason why we have this agency in the state of Nevada, to help workers get their benefits and go through the appellate process. And again, actions speak louder than words. So if they say, yeah, we're trying to help people. No, you're not. You're not trying to help people. This process could be simplified by simply allowing service by mail. These procedural technicalities should not be a basis to deny these claims, but the Employment Security Division just seizes upon any possible flaw to get a case dismissed, and that's just wrong as a matter of public policy.
If you do choose then to serve things personally, just, you do have to serve the ESD administrator in Carson City. So if you know somebody that lives in Carson, or, that's great. You do have to have it served by an
Someone
adult.
that's not you.
Yeah, someone that's not you, that's an adult. The safest way to do that is to hire a processor. That does cost money. But if you don't live in Carson City, that might be your only option. And you might have to pay a process server to serve the ESD administrator. But you do have to serve one copy of each summons. And remember, there's for unemployment cases, there's 4 parties. For PUA cases, there's 3 parties. For the process server, you have to give them every single copy you need to serve plus each summons.
But if you can get to that office in Carson City, it's pretty easy. And there's a receptionist. The receptionist will take the summonses and the complaint. And if that happens, then you're good according to Rule 4, which is summons service, which Ray is talking about. The administrator has the obligation under the law to serve the rest of them, like to the employer, if there is one, or to the board of review. So all you need to do is get someone who's not you, who's not interested in the lawsuit, to deliver it to that office in Carson City, and you've effected proper or the most complicated and unwieldy service of process, and you're good.
Again, we do have instructions on our website. If, please feel free to look at those if you're in this process and trying to figure out what to do. And then again, if you would like to see if you qualify for our assistance, we'll have our contact information.
If anyone gets that motion to dismiss, please contact us, because that would be something very easy to argue, and you should win if you get a fair judge.
So once you serve the petition, first of all, we should say you do have to serve within 45 days. So you do only have 45 days to get the petitions and the summonses to the ESD administrator. So you have to do that within 45 days. Once you do that, then it's up to ESD to submit what we call the record. So there's going to be a transcript from the hearing that you attended. They will transcribe that hearing and file it with the court. Once that record is filed, you then have 40 days to file your opening brief. Please be aware, local rules might have different timeframes, and the judges might have their own briefing schedule. So please be aware that once you file, you need to, if you e-file, you need to have a good email address that you give them, that they will, because they'll only email you service. Or if the court is going to mail you something, they're going to mail you potentially a briefing schedule. So please be attentive to those things. Otherwise, by statute, you have 40 days to file your opening brief. In your opening brief, this is your opportunity to lay out your legal arguments for why you should get your benefits. Now, please remember, we talked about in the earlier slide, those 4 grounds. Make sure that all of your arguments are going back to one of those grounds. It is an administrative appeal. It is different than, just appealing a decision from a judge. We can, unfortunately, there's a lot of legal theories that go behind that, but essentially you just need to always tie it back to one of those 4 grounds we talked about at the beginning.
And I mean, just talking about it, Ray, I think what we need to do is develop a model sort of opening brief memorandum of points and authorities.
We do have one for regular UI cases. I think it's a misconduct brief. I can post that on our website, but we will take a look at it. And then we would need one for PUA.
Right. I've done a couple now, so I can just adapt it, and we'll try to post that as quickly as possible, because this is really where the rubber meets the road. And you really, you need to describe how you were screwed over, basically, as I sort of pointed out earlier. The petition is not the place to do it. This opening brief is the place to do it. So sometimes there's a lot of unfairness at the hearing, but it doesn't really amount to a legal argument. And, that's sometimes difficult for people to figure out. But if you have a model form, you can sort of check the boxes and see what applies to you. Substantial evidence, you're rarely going to be successful with substantial evidence. So you really want to get it into a legal issue of why the referee or the appeals tribunal didn't follow the law. And if you can do that, you have some chance of prevailing.
And then ESD will have a chance to file an answering brief, and then you get as the petitioner, you would get the last word, and you can file a reply. And the reply is usually very, these are all also page number restricted. Please keep that in mind. The reply is much so. So with your reply, be careful. You want to make sure you get all of your arguments out in that opening brief, because the reply is really going to be limited to what it can do. All right, we kind of already talked about the arguments. Any final thoughts on arguments, David?
Well, some courts don't even hold oral argument. I know with the Employment Security Division, they will almost always request a hearing because I believe they think they have an advantage in requesting a hearing. It just clogs courts' calendars, and sometimes there's kind of needless hearings that are conducted. But if it is a hearing, like in Clark County, you can access it by using Blue Jeans, which is like Zoom, and you don't necessarily have to go to the courthouse. You can just call in or Zoom in or Blue Jeans in or whatever. So the argument is basically what you put in your brief. So there's no Clarence Darrow moment where you can convince the court they're going to do something they're not intending to do.
And again, as we said, yeah, don't worry about who that is.
Right.
Just remember, you do always want to tie it back to the decision was arbitrary and capricious. The judge abused their discretion, or it was improper as a matter of law. You can Google all those words, but essentially, like David said, if they violated the CARES Act, the Department of Labor regulations, NRS 612, whatever it is, that's what you want to be arguing is you always want to point back to for PUA, you always want to point back to the CARES Act or the Department of Labor regulations. For UI, you always want to point back to 612.
Well, an example could be what typically the Employment Security Division does wrong is if you're not actually working on March 15th, 2020, they'll deny you because your separation from work was not COVID related. So that's wrong as a matter of law because the Department of Labor has said if you're eligible, even if you've been fired because of fraud, you should, and you're otherwise eligible for PUA, you should get those benefits. So that's a situation where, you in theory were screwed over. But when you convert it to a legal definition, it's wrong as a matter of law because the Employment Security Division is just interested under PUA as whether you're separated, you're not working because of a COVID-related reason. They don't care why you were separated from your prior employment, but the Employment Security Division always commits a mistake of law by looking at that and saying, if you were fired for a good reason, we're not going to give you PUA. That's just wrong as a matter of law.
All right, so that's the petition for judicial review process. That's when you've had your hearing, you appeal to the board of review, and you need to appeal again to court, to district court. All right, we're gonna move now back to the writ of mandamus. So again, this is where you might not have gotten a hearing, they deemed your appeal invalid, or they haven't issued a decision and it's been a very long. David, do you want to go through the writ of mandamus?
Sure. The writ of mandamus, again, is not when you go to the board of review and lose. That's a petition for judicial review. The writ of mandamus is when you don't get a hearing, when the board is taking 10 months to decide something, when your benefits have stopped and you have no reason, you don't know why they were stopped. These are reasons to file a writ of mandamus when you don't have an adequate remedy at law. So the writ of mandamus, when the law requires the Employment Security Division to provide benefits or provide a hearing or to issue a decision and they're not doing it, or there's an excessive delay, you can file a writ of mandamus. The writ of mandamus is different than the petition for judicial review. It's not, a petition for judicial review is created by statute. So you have an adequate remedy at law and you follow that adequate remedy at law. Writ of mandamus is discretionary and it's extraordinary. So a district court can actually deny it and say, no, I'm not entertaining this writ because I don't think you have grounds. So just be advised, you don't want to rely on this writ of mandamus because it can be dismissed outright by a district court. And you only use the writ of mandamus as a last resort if you're just waiting for an interminable amount of time. Anyway, you switched slides. It doesn't matter. The point is, with a writ of mandamus, there will be a filing fee. It's not like the petition for judicial review in 612 that doesn't allow for a filing fee. You will need a civil cover sheet and you will need to file a petition. Now, the good thing about a writ of mandamus is there's nothing in the statute to require the petition to be served. Now, if you get a writ, you have to serve that like a summons, Rule 4, and what we were talking about with the petition for judicial review. But with the writ, you can simply just mail that off to ESD and the Attorney General's office, and that's sufficient under Rule 5 for the petition for a writ of mandamus. Now, once you file that, you're probably going to have to do it electronically. It's assigned almost immediately to a department. And probably you might want to wait a few days before you contact the court, but you want to contact the court, ask the clerk what's going on. Will there be a briefing schedule? Has the court looked at my writ? If you, like in Clark County, simply file it, there's no way the court has noticed that you filed it. So that's what you're doing by calling the court, notifying them that you have filed this writ. And again, the court can deny the writ. The court can grant the writ and order the department to issue a decision or disperse benefits, or what they usually do is just set out a briefing schedule. The Attorney General's office will have 40 days to respond to the writ, and then you'll have 14 days to file a reply, and then the court will decide. So even with these writs, even if you get the attention of the court, you could be waiting a few months before there's any activity by the court. But what we usually see is the Attorney General, their office will contact the Employment Security Division, and if it's simply just scheduling a hearing, that's what they'll do. And what they do by doing that is moot. They make your writ meaningless. So if they schedule a hearing and that's all you want in your writ should be dismissed because they've granted the hearing. All right, I'm done.
Yeah, no, that's fine. And we've kind of already gone over the possible arguments. We've already discussed our sample writs for the delays. Those are still on our website. And we're going to update 2 new writ petitions for the invalid appeal.
Right. Sorry, Ray. I guess I wasn't done. So what we've seen from pro se people, and it's not our writs, is sometimes they will come in and argue that service of the writ was wrong. Again, that's not the case because Rule 4 is specifically provided as service, a summons, and the writ with regard to the writ itself when it's issued by the court. But if the legislature points out a method of service and they don't mention service of the petition, then it's got to be Rule 5. So that's the argument. It makes sense in terms of statutory interpretation, And service by mail of the petition for a writ of certiorari should be allowed. That's what a court should decide. They're also going to say that under PUA, you don't have a private right of action. That's not true. And plus, you don't need it for a writ. Writ is extraordinary relief, and you don't need a private right of action. And then finally, what they rely on is the perfect storm. We're so busy, we can't do these things. We can't issue a decision or hold a hearing. I mean, that's all these arguments are basically, they have been successful in court, and I think they're successful in court is because courts really don't want to mess with these issues, and they kind of abandon their obligation to hold the Employment Security Division their feet to the fire and make them do what they're supposed to do.
All right. We do have other petitions for writ of mandamus videos that you can view. We kind of go through, as I said, the one that is up on our website, which is for the delay. We will post the other ones, but they are pretty, fill in the blank. You do just generally have to fill in dates or simple information. So those will be up on our website hopefully today. And I will modify the petition for judicial review for the PUA. Now, we've kind of discussed this already, but just to kind of reiterate the service of the petition for judicial review by mail, it was a decision in State v. DeRosa. That was the Supreme Court decision that authorized service by mail and petitions for judicial review. Now, it does apply to appeals of administrative decisions. That would be our argument for NRS Chapter 612, but it wasn't technically an unemployment case. So again, use your best, whatever you believe suits you best in terms of how you want to serve that petition for judicial review. And then, the issue that we're kind of really predominantly seeing right now for writs of mandamus is the invalid appeal. And there is no legal basis to invalidate appeal. Once you submit your appeal through your PUA portal and say, I disagree, I am eligible, whatever it is, that should be enough to grant you a hearing and give you the opportunity to be heard on whether or not you're eligible for benefit. So those are the two issues that, we're kind of seeing at the moment. And we will be posting the new PUA writ petitions online.
And once again, an appeal to anyone who's getting a motion to dismiss when they serve by mail. It's a legal argument that's pretty simple, straightforward. If you want to be the next DeRosa, please contact us because it does apply to 612, and there's really no reason not to apply it to 612, which is the unemployment petition for judicial review for PUA benefits. Sometimes we use, anyway, this is just a trap for the unwary. This is why people don't have access to justice. And if the Supreme Court is really interested in helping people, they will allow service by mail.
So that's basically the conclusion of this presentation. I am posting right now all of our contact information. Oh, oops, went too far. Please feel free to call us, as David said. We have our toll-free numbers posted. The top one is for Las Vegas. The bottom one is for Reno, so Southern Nevada, Northern Nevada, but obviously just either one or perfectly fine. We will get you to the person you need to talk to. And our website, as I said, is nevadalegalservices.org. And we are also on Facebook, Twitter, and Instagram. So please feel free to, get our contact information there.
And let's hope 2022 is a better year for everyone and we don't have these problems in the future and we all live in harmony.
And do please be aware if you do want to contact us. I know there was a question in the chat about that. We do have online intake through our website. Unfortunately, because of the holidays, our offices are closed next week. You will not be able to submit an application online until January 3rd. And, if you do try to call us starting today at 4 o'clock, we will not be available until January 3rd. I do apologize for the inconvenience for this, but this is the holiday time, and we are lucky enough that our staff get to have next week off. So please be aware that you might not be able to reach us until January 3rd.
And just listen to that Jackson Brown song, Running on Empty, because sometimes the injustice that we see, you kind of feel like you're running on empty. And it's just kind of like anger and vinegar, and it keeps you going. Because, look, this is a problem. We're aware of it. We're trying our best. We don't have the resources to take on every issue, but we do know it's a problem, and we are trying our best to help people.
And I will get those petitions. You know, our website will be updated today. So just keep that in mind.
All right.
But thank you everyone for tuning in to our Thursday live stream. We will be back after the new year. We probably will be back later in January. So there will not be one early in January. We will be looking at later in January. Again, like I said, you know, we are open to suggestions. If there's anything of interest that you guys would like to ask us questions about or want more information on, please let us know. But otherwise, thank you very much for attending, and thank you, David.
Thanks, Ray.
And we will see everyone next year. I wish everybody a happy new year.